not physically possible. Great to be with you guys. We are
You
live.
a little Mediterranean in you.
Not well. It's just that northern German thing. I don't know. Just got nothing. Got nothing. I only shave every 3 days, so why would I need to grow a beard? I mean, it's just crazy. Hey, it's great to be with you all this week. The first thing we want to talk about today is I've been getting calls and emails, and this is about our 601 delay litigation with the American Immigration Lawyers Association. We're so grateful to them, and for all those working with us on this case. But we received the much anticipated, Aaron, much touted, much ballyhooed government motion to dismiss.
They took all the time that they could to produce this work of art.
It is. Well, I don't want to comment yet, although I did comment on Twitter. But Aaron, you're kind of our lead on this. What is your take on the government motion to dismiss?
Well, first I'd say no surprises, so it is what it is. So I think there's two things that they say. They say there's no jurisdiction to hear a claim like this. And taken to the logical ends, that means that in a case like this, or basically any application for an immigration benefit, because almost all of them are discretionary, there is no requirement that they ever issue a decision, right? The courts could never step in, according to their argument, and say this is an unreasonable delay. So
wait. Are you saying that they said that they are the executive branch of the government are without judicial oversight on how long it takes them to do a job, if they ever have to do it at all?
That's what they're saying. They're saying that they are that they have effectively gutted the APA, and there is no judicial oversight.
They did take money to do this. It's not doing this for free, right?
It's not just like basically dissing the judicial branch, but it's dissing the legislative branch as well, where they're saying if they decide that they're not going to carry out, adjudicating something that Congress created, that there's nothing that that can be done about it, except Congress, I guess, passing another law. But if the judiciary can't enforce it, then what good is that anyway?
I want to quote from the very first page, or I guess technically page 2, what the government said here. Here's what they said. The court should dismiss the complaint because the complaint, which is an unreasonable delay claim regarding the processing of a 601 waiver, because the statute that makes this waiver created divests the court of jurisdiction to review any decision or action by DHS regarding the waiver. Now, I have a question about that. I can read. I'll read. Don't they actually have to take an action for the court not to have review?
Right. There has to be a decision
or an action.
If they can't review it, if there's been no decision, there's nothing. That doesn't apply.
I guess this is the government's argument, Aaron. Get me if I'm wrong. Their inaction is in itself an action. That's their argument.
Right.
Oh my God, I love that argument. That's going to go over really well with the judge. I think that's a winner.
Then I wanted to talk about their second piece of their argument. So then they say, even if the court has jurisdiction to step in here, it's not an unreasonable delay because basically we're doing our best, COVID, yada, yada, yada. But
there was no yada, yada, yada. It was just COVID.
Yeah.
And that was the only excuse that they offered in that whole thing, as far as like what was behind the delay.
And then let me go through and highlight one piece that jumped out at me and kind of upset me a little bit. So they go through these factors. So when you're looking at an unreasonable delay case, they're called the track factors, and they're factors that courts are supposed to consider about whether the delay is reasonable or not. And in our complaint, we had noted that USCIS and DHS, the defendants in this case, had said when they put this process into place that it was going to alleviate family suffering, financial and emotional burdens on families associated with the process as it existed before, realize efficiencies, and streamline the process. So that's what they were trying to do with this waiver process. And they explicitly acknowledged that their purpose was to help alleviate these burdens on families. And this, that's not our words, that's their words, right?
Yeah.
Now in this filing, when they're looking at the factors, and when we had talked about how hard this is on our plaintiffs and on their families, they give that the short shrift. And what they say here is the problem with the allegations of the plaintiffs' injuries is that they're not attributable to delay on the part of USCIS. The injuries are caused or seem to be the result of their unlawful presence.
Whoa, wait a second. You're saying, well, are they lying then or are they lying now? That is really the question I want to ask.
Well, they're saying we put these things into place to alleviate these problems, and we streamlined this process. And now they're saying, well, this is your own fault for having.
Right. They had it coming.
Yeah, they had it coming. Exactly, Greg. That's what they're saying. And that jumped off the page to me as something I didn't like.
This is the way things are in a Trump administration. Isn't Joe Biden president? I thought he was going to fix all suffering. Kumbaya, baby. Aaron, this is crazy.
It just surprises me 1 week after the next that this administration chooses. They talk a good game, but their tell is what they choose to litigate and how they litigate. And it's been in one case after another that they may say one thing in the nice speeches that are given by leaders of the agencies and by the White House about immigration, but what they choose to litigate, the arguments that they're making are completely contrary. So, that's, I think, the big tell with them.
So, yeah, that's what we got. That's what we have to respond to. And it's already in process, in motion, the response. We're looking forward to getting our response on file with the court. The way that this court's rules work is that we can file our response at any time up until, I think it's the 24th, whatever that Monday is of April. Let me pull up my calendar just so I have it right. Yes, the 24th of April. And whenever we file that, it doesn't matter. Their reply, which completes the briefing on this motion, is due the 28th. So that's when briefing will be completed on this motion. And my expectation, the judge can do what she wants. So this isn't for sure, but my expectation is that the judge will probably rule on the motion for class certification and the motion to dismiss probably at the same time, potentially in the same order. And she can do that at any time after the 28th, or she could set it for oral argument. So we will have to see how she wants to handle it.
I would expect an oral argument in this case, because if the government loses the motion to dismiss, and we believe they will, that basically changes the nature of this case. Because if they lose the motion to dismiss, then their next argument is, at that point, we will argue for discovery. We need to depose the director. We need to get this information, that information. They will say, oh, no, you don't get any of that. No. You don't get any of that. So all you have is what's publicly available or what we might give you if we feel like it. And that is the next fight in this case. But they are on the bad side of that argument once they lose the motion to dismiss, I think. And because they do not want us deposing the head of the Potomac Service Center. They do not want us deposing the person who decided to transfer 170 cases from Nebraska at 36 months to Potomac at 46 months. They do not want us to depose the new head of the virtual service center, which we need to talk about in a second here. So the government delayed until literally the last minute to file their motion to dismiss after they had announced the virtual humanitarian service center. Greg, you're an expert in the tea leaving at the USCIS. Do you think there's a connection here between the creation of the virtual service center?
I'm just wondering where you sue them if it's virtual.
Well, and then my question is, what do they mean by the word virtual? That you can work from anywhere, or they might appear to be working, but they're really not.
No, it's hard to say. Although I did want to actually just report that as of this morning, we have started another round of transfers of cases. after about 2 weeks of or 2.5 weeks of
What did we
inactivity
see
there.
this morning on transfer?
So yeah, I mean, I think we were a little too optimistic what that meant at the beginning when those cases were being transferred. At this point, I'm not sure that, and it may have something to do with this virtual business, this virtual service center, about how they're repositioning in order to be able to adjudicate those cases. But I did want to report that there looked like there were about a half a dozen transfers this morning on there, and I don't know if there'll be more.
And this thing about the virtual service center, Greg, did they do this because we sued them?
I don't know. It'll be interesting to see if this is the only thing, what kinds of cases that they work on there. I'm like all for them taking measures to try and, deal with it. Absolutely. But we haven't seen any evidence that they want to work on these cases at all. So I'm not sure, like, announcing this.
They're calling it the Humanitarian Service Center. Now, there are humanitarian visas at the paroles. 601s have never historically been called humanitarian.
Right.
And yet it's the first thing they're working on. Clearly, this is in relation to a lawsuit. There's no doubt about that.
Right.
But here's my bigger question. Why aren't 601s included in this? These are the same exact people, except they're stuck outside the country.
Yeah.
Why aren't they humanitarianly? Does that work?
Because our case has not been filed, but it's about to be filed. So I have a feeling there may be something you're saying there.
So these are people that are going to work from home. Now, keep in mind, 601As are filed on paper. So does that mean they're physically shipping somebody's private information to some gal's house in Davenport so she can work on a file? Or are they literally paying somebody to scan the file, hoping they get all the pages, which, as we all know, they frequently do not, so that can be emailed to this person on their personal computer? There's a lot of sketchy stuff here. I
don't know if they actually have a personal computers when they're working at home.
Well, here's my next thing. Remember we talked.
I would hope not.
About this.
They assigned a laptop.
We talked this idea that they located these service centers in areas with the unemployment rate is like 1%, like Lincoln, Nebraska. So clearly they're going to have to go to places in which there's a higher unemployment rate. I don't know where that is.
No, I'm all for them to, being creative, using technology, trying to do things in order to be able to spread the word. That's all good. We want to encourage them to basically manage their workforce in a way to be able to produce results as quickly as possible for people. To the extent that that's happening, we're all for it, but we're not seeing the evidence yet that any of their initiatives are working.
I in the very last page of their motion to dismiss, they cite to an they cite to an article that we cited about the delays. They said the article reports that defendant Chadu is attempting to address the delay issues by seeking more funding, both through appropriations and fee increases.
Yeah.
Along with further plans. Now, so basically said, we know you paid us $715, but we already spent that money. We have no money to do these cases. So we're asking for more. Now, on that issue, yesterday, a bunch of congressmen, I think 68 of them, sent a letter to the Appropriations Committee in the House to double the funding requests that Chadu had asked for. So first of all, she clearly didn't ask for enough money. Two, she promised last year she would everybody be fully staffed by October. This is I cannot wait. Now, this is why they're not letting me write this response because my level of snark might not be but I would love to argue this case because I think this is such a tell. What they're saying here is, Judge, we simply don't have the bodies to get the work done that we're taking in. That's what they're saying.
Well, but that would make sense if they were slow about it, and they could say, like, we're so overwhelmed and we have all these people working on it, but they just can't get, the cases turned around quickly enough. But there's no evidence that they're working on the 601As at all.
Well, in fact, they make a really interesting argument early on in their brief where they say, hey, Judge, from 2018 to now, we have adjudicated 138,000 601As.
Right.
We currently have pending 146,000. And so far this fiscal year, which is the first half of the fiscal year, they've adjudicated 2,900.
They should have just stopped at the end of a sentence.
They should have.
It was like such an admission. It's like, why are you working on so few cases this year?
So on average, over 5 years, they adjudicate 40,000 a year.
Right.
But this year they've only done 3. Doesn't that just literally raise the question that you clearly made a choice
Yeah.
to not? This is such a terribly written, I'm sorry, it is a terribly written, illogical motion to dismiss.
Well, it's also, they're misleading with numbers as well, because in 2018 and 2019,
they were working
they
on
adjudicated the bulk of all of that was adjudicated. They said till now. That's like, saying it's like they make it sound like it's sort of like they were working on an even amount per year over the last several years, and that's how many that they worked on.
Well, it's like they forgot.
Front loaded as far as what they worked on during those years. I'm pretty sure all those adjudications were in 2018 and 2019.
Oh, absolutely.
They've done nothing basically for the last 3 years.
Exactly right. And
4
it's
years.
not like that information is not on their freaking website.
Right.
I mean, it's literally right there. Of that, I would bet 85% of those are before all of our clients filed cases. And when they filed their cases, there was a 12-month processing time.
Right.
Anyway,
I think it was 4 months.
Aaron is writing this and not me, because it would sound.
I think in 2019 they were at a 4-month processing time, is my recollection.
It was close to 4 to 6 months. I mean, we do a lot of Aaron. We do a lot of these cases. And I met with this morning with one of our plaintiffs, called me, and we spent about a half hour on the phone. They made an expedite request because she was in the middle of a very dangerous pregnancy in June of 2022. They filed in August of 2020. In June of 2022, she filed an expedite request because she was in the middle of a very dangerous pregnancy. In December, they denied the expedite request, saying, "Have you already had the baby?" Yeah. So this is going to be fun. I am going to this oral argument. I am booking my ticket to Seattle, and I'm going to this oral argument. And then your job,
I think I'm going to go with it,
Aaron, is to belt me to my seat during oral argument. That's it. Maybe keep my face from expressing my utter disgust at this. All right.
What else do we have?
Man, we're going to talk about Jane, EB5. Let me
Yeah.
find scroll up here to our, I know it's here somewhere, AB5 litigation. Jane. So yesterday afternoon, I filed our reply brief on the issue of Rule 56D discovery. This is highly technical stuff. It's crazy stuff. Very little case law on 56D discovery. I want to thank our colleague, Matt Galati, who's working with us on this particular case. Basically, the government said, you know what? You don't get to find out why we're taking 5 years to adjudicate EB5s. We're just telling you that that's how long we take, and that's good enough. And our response is no. You've given inconsistent affidavits about why it's taking so long. You have taken people out of order that filed after us without telling us why. You can't get to do this. So we're waiting now for the judge. We have a hearing, an audio. We have a Zoom hearing with the judge on the 17th of April. We sent an email out, I think last night or yesterday or today, to our EB5 clients. You can join that. It'll just be me, the government lawyer, and the judge in the pictures, but you'll have audio for the Zoom for that. You don't get to scream and yell from the peanut gallery, boo, yes. You don't get to do that on these Zoom calls, but you'll get to participate in that. And then we'll see if the judge rules against me and says, Mr. Cook, I'm sorry, I can't let you see the secret inner workings of Hogwarts in DC. You'll just have to file your motion to summary judgment based upon what you know. Judge could do that. Or the judge could say, you know what, I think you should depose Urchadu. I think that'd be cool. Or depose the head of the immigrant investor office. Yeah, let's find out what's really going on. The good news is our colleague Matt actually lost another case with the same name a couple of days before that And in that motion for summary judgment, the judge said, different judge, same district, different judge said, you didn't even ask for additional discovery. Okay, we have. So I will. So the hearing will be the 17th, which is 2 weeks from yesterday. If I did my math right, yeah, 2 weeks from yesterday. And we will then. I anticipate getting this judge has ruled very quickly on everything we filed. She's a magistrate judge. So I would expect by the end of April, we'll know whether we have to file. We'll have one additional week to file a motion for summary judgment ourselves and a response to the government motion, or the judge will put the motions on hold and allow me to do discovery. So there you have it. Aaron, we kind of mentioned this, but we're preparing our 601 litigation.
Yeah, I'm excited that we have our first group of plaintiffs. So thanks for those who have signed up. We are working on getting the complaint. I had told people I thought it's possible that it's filed this week. Actually, we'll see. I'm going to circulate a complaint amongst our group, likely tomorrow, and then we'll work on getting it finalized. We still have some decisions to make about where, but I'm excited because, as Chuck mentioned, these are every bit as egregious, these delays, as the 601As, and in some respects worse because the clients, the plaintiffs, are actually abroad, generally separated from their families, waiting to come back and just waiting these interminable waits. So we're excited to get this case going.
And Aaron, some of those went down with the 601A approved, and then the consulate said, no, you need a different 601. So they went down thinking they'd be gone for a week, and now they're gone for years.
Yeah, and those cases are actually even more egregious because they've actually already made the legal determination that they need to, that there's extreme hardship. So they should be able to, even if a new 601 isn't needed, it should be fast, and it is not. So yeah, we're looking forward to that.
It's a nightmare. So we're looking forward to doing that. Greg, we've got our Uniting for Ukraine fee litigation going on. You know where we are with that? We get a quick brief update for that.
Yeah, we have a so we're moving along. We had plans to file it in one jurisdiction, but I think for lack of plaintiffs, we're going to be looking at another one. But I think we're pretty much ready to go as soon as we make that determination. We're reaching out to plaintiffs in the proposed jurisdiction to see just to make sure that they're okay with it. But these are people that were in the Shumalina case, so they presumably are comfortable with litigating because they already have been.
And they want to get their money back. The money that immigration stole from them.
Yeah,
that's what they did. All right, let's add some. By the way, no update. There is no update. No update. No update. No update. No information on any of the lottery cases. Sorry. It's only April 4th. All right, so let's go here. Diaz, the family need a work permit. Yes. So Aaron, do you want to just confirm that the government, Jesse, who's not here today, we miss Jesse terribly, presented to the government, hey, why don't you just give them work permits? And they said they would take that to USCIS, right? To their client.
Mm-hmm.
I think they're not going to be in a negotiating mood until after the motion to dismiss.
Okay. In weeks? No, there's no 601. This is litigation takes months. That's what this is. Litigation takes months. Let's go. Anyone more evidence? Just look at the Google reviews of USCIS service centers. That's somebody gave a 5-star review to a service center. I'm just thinking, what kind of happened in their case?
That sounds fun to look at those.
Service center examiner. Oh, anonymous. They don't know who's reviewing.
There's actually our local immigration court has a Yelp review page, and it's higher than 1 star, which I can't believe either. But that's good. How about the 3 dates on 601? These 3 dates on 601.
What are the 3 dates?
Tim,
if you could clarify actually, and then look at the next one.
Okay, it's April 17th. Okay, so April 17th, the 26th conference, that is about the class certification. So there's a class action request pending. That's the date the judge will ask for argument on the certification of a class to include every 601A as beneficiaries of this case. That's what happens on that day. She'll presumably make a decision pretty quickly after that. The initial disclosures on May 3rd are basically the government's supposed to produce evidence that supports their position. And presumptively we'll have a decision. We might have a decision on the motion to dismiss by then. Joint status report and discovery plan. Again, that comes out of the initial disclosure conference about we're going to want discovery. Government doesn't want to give discovery, and we'll fight about that.
Tim, that's an important point. Thanks for making it, because as we've indicated the whole time, our position is that the discovery piece of this does not stop. It's not delayed just because they filed a motion to dismiss. And the judge agreed with us. Now, the dates were a little bit delayed anyways, but the dates are there are still deadlines. What the government had said is, hey, let's not have any deadlines for discovery. Let's not even talk about it until this motions practice is complete. And the judge said, no, we're not going to do that. So we're proceeding on those things as well.
Motion to dismiss is on its way out, right, Greg?
Yes.
Yes. I also posted
but I understand.
I also posted a link to it in a Twitter tweet that I put out this morning. So you can look at it there on and download.
Well, the draft, and then I think Aaron made some changes, so we're incorporating those.
I did put the government motion to dismiss in a docs thing that you can download.
Right. It should be ready out today.
The HMB FOIA. I did sue, Ash. My litigation's pending. Government has 30 days to respond. I think they got like 10 days left. We'll find out. I also, Greg, thank you, by the way, for reposting my blog.
Your rant.
It was definitely a rant, but I got to tell you, the more I dug into it, I didn't rant enough. And we are hearing all kinds of crazy stuff on our listservs about people being contacted by companies they didn't know filed for them. I mean, it's crazy stuff here.
Yeah, I mean, I guess that one of the things that sort of makes me curious is why we don't know yet how many people filed.
This is stunning.
Have they ever, in previous years, they always announce it at the time, don't they?
Or within a short time afterwards. It's been a week and change at this point.
Yeah.
And keep in mind, as I pointed out in my blog, all of this is pre-done into a database by the employers.
Yeah. Right. No, I'm pretty certain they know the moment the lottery happens exactly how many people.
They know everything.
Granted, because the system just rejects automatically applications that aren't filed correctly. So it should be everything that actually went through. That's their number.
They know exactly. And I don't know, in our office, our approval rate for master's folks were 50%.
Yeah.
Our approval rate for bachelor's people was 2%.
Yeah, which is the master's number is consistent with prior years, which leads me to believe when we get our numbers, we're going to see that the master's number didn't go up at all. And it's all in the regular lottery, which is exactly what we have been predicting based on what we know is happening
way worse than last year.
with the gaming of the numbers. So that's that being said, I mean, I as far as what our options are, obviously we have your FOIA, which gets us part of the way as far as like giving us insight as far
from a couple of years ago. I have to do another FOIA for this year's numbers,
right? Which that's helpful in terms of first of all, if they respond and you're may have to litigate on that, but it tells it's the evidence that we it's partial evidence of what's happening as far as like it would support the hypothesis that we have, but at the end of the day, I think USCIS knows what's happening. We know what's happening, and either they don't care because for whatever reason it's a good money maker for them, or it's convenient, or they choose not to do anything about it because the solution may not be as easy as they want, or they have to admit that they created a system that is not working. But in any case, I think if we actually got to sit down with them and have this discussion candidly, they would probably tell us, yes, we know you're right, and we also don't have an easy, that we either politically don't have an easy fix, or fiscally don't have an easy fix. I don't think technically, though, it's all that hard to do the fix that we've suggested, which is you do a lottery based on passport numbers on there instead of on a.
You get picked one time. You only get picked one time.
Yeah, that's it.
Where is the Wolverine? I have no idea what you're talking about.
Who's the Wolverine?
I don't know. Oh, he must be talking about Jesse. Or is he talking about you? I don't know. I mean,
well, I don't know unless Jesse went to the University of Michigan.
Well, I don't know. My case was transferred. What does this mean? We're all playing. No, as Greg noted, there was a recent batch of transfers today, and we don't know what it means.
We can't tell from the data scraping where the cases go. You guys can tell us if they tell you. Do they do that? Do they send when a case is transferred?
Some people were told it was transferred. They didn't tell them where.
Right, but right. So how do you even know? Let's just say you're just average Joe who's not into mass litigation. You decide you want to sue based on where their case is pending. How would you know where to sue?
You wouldn't.
USCIS has said after Chakrabarty, you should sue where the case is pending. But you have to know where it's pending in order to be able to do that. It's sort of it's an impossible situation.
Gary, we talked earlier in our broadcast about the heart processing center. I think it's hilarious. Because it makes me it makes me
heart. They probably had a committee that worked on that.
Oh no, that actually took about 10 days of management meetings. The heart. And good thing it wasn't called the Family and Refugee Center. Oh my goodness, that would have been awesome. Get Fart on the phone, Bob. They haven't been working. They might have been working to create the center, but they haven't. There's nobody. I got the impression, Greg, in the announcement. There's nobody actually working in this center.
Right. They don't, as far as we know, there's not a single employee.
There's not a single employee of the center yet. Can 601A be virtually adjudicated when they are paper bit? Well, they could. They could just scan them. Rox, bring us how I joined 601A. I've been waiting for approval 2 years. Well, you better let Ciudad Juana, let your lawyer know that you can't come because you need a 601A waiver. You're supposed to have updated when you filed the 601. They should know automatically that that's pending, right, Aaron? Mm-hmm. Yeah, so you shouldn't have been scheduled, but I wouldn't wait till May. I would tell them now you're not going to make it. Will the judge about throwing out the case? Again, we'll probably know. I think we're going to know by the end of the month on the dismiss. You're going to go to court. I'd like to get another stay. Yes, they'll get another stay.
By the way, I mean, it's like, well, we're pretty confident in it. People should always still remember if this is litigation, there are no guarantees. So, if it did get dismissed on there, obviously we would reevaluate options, but I don't want people to think that we work under the assumption none of our cases are, subject to bad.
But we keep fighting.
Yeah.
Daniel, Aaron making payment on 10th. Can I still make it the first lawsuit? Yes, I believe you can, right? 601, the 601 case. Still make it?
It's tight. You can. If you don't, then you'll be in the next one.
This round.
Yeah.
If you don't, then you'll be in the next one, which the sooner we get more people signing up, the sooner the next round goes.
EB4, I don't think we'll see any movement in EB4 for a year, personally.
Yeah.
I mean, there's just too many SIJ cases. There's tens of thousands of SIJ cases. Saludos, Leonel, Equinox 2, 4 to K6. You know which could we file at 6? We do not know yet. Aaron, it's unlikely to be Nebraska. Is that right?
I think so. So far, yeah, I think it's unlikely.
Yeah. Are you making payments yet? Okay, we already mentioned it. Hard plaintiff. There you go. Maybe I wish. That's a great picture, by the way. All right, it's great to have been with you this week. Hopefully, Jesse will join us next week. Next week is my last class. I'm so excited. Next week, I don't have any more classes after next week.
Summer vacation.
Yeah, at least for law students. All right, it's spring break here in Georgia. Hopefully, it's not spring break by Aaron because it's snowing today.
Tornado season by us.
Yeah, tornado season. Stay safe, Greg. We'll see you guys all next week. Have a great week.
Bye.
Bye.